Hi, I'm Steve Richardson, and this is the July 2019 episode of Lunch with a Lawyer. So put down your sandwiches, grab your phone, and we're going to talk about some legal stuff. Today we're going to talk about the 5 lies that people tell themselves about debt. People that are in financial difficulty that owe money often will tell themselves things either because they read it on the internet, somebody told them it once, they saw a YouTube video, or something that told them that this was true, so they believe it because they think that that'll make their problem go away or be easier. And really, it doesn't. And it's better to know that these are not true and deal with them realistically if you're trying to deal with your debt and come up with a solution that really solves the problem rather than putting it off or kicking it down the road. So I'm going to talk about these 5 lies that people tell themselves, 5 myths that are out there. And I've heard them from people. I mean, I've been doing this for a while, and in talking to folks over the years, I've heard people say this. I just kind of shake my head and say, well, no, that's not true. So I'm bringing it to you now. All right, the first lie is, well, I checked my credit report, and the creditor charged it off. That means I don't owe it anymore. No, it doesn't. You still owe it. That charge off is done for tax reasons, which I won't go into here, but it has to do with how income is taxed to the creditor, and that when they charge it off, they're saying, we're done waiting for you to pay. We're not assuming that you are going to pay. And in effect, that charge off is when you are considered to be in default. So when we talk about statutes of limitation, those run from the date of charge off. So that is an indicator to you when you see that charge off, and if there's a date next to it, that's when the clock started ticking, and you may well expect a lawsuit from them or phone calls and letters from debt collectors and things like that you owe the debt. So please, don't take comfort in the fact that your creditor charged off a debt. That's actually a bad thing, not a good thing, and it means you really need to address this debt soon to get it taken care of before it really does a number on your credit score. All right, so charged off, you still owe it. The second myth is, and I've talked to people about this, that, well, I don't live in I've been sued in New Jersey. They have a judgment against me in New Jersey, but I live and work in Pennsylvania. They can't get me. Well, that's not entirely true. And there are a lot of exceptions to that. And if you find yourself in that situation, you should really talk to an experienced collection attorney to find out where you really stand, because you may not be as safe as you think you are. Okay. Now, let's say you're living in Pennsylvania, okay, and you're working in Pennsylvania, but where are you banking? Okay. If you're banking with a banking institution that has branches in New Jersey, they can come after you. All they have to do is serve the bank levy on a New Jersey branch of your bank. So you may live and work in Pennsylvania, but a bank levy, if they know where you bank, can certainly put a hurting on you if they do that, and they can as long as your bank has a branch here in New Jersey. Now, if your bank has no New Jersey presence whatsoever, or if you use exclusively an online bank, then that money may not be reachable by creditors, because there's no presence in New Jersey. There's nowhere they can serve the levy papers. Now let's say you work in Pennsylvania. Okay, well, they can't garnish my wages because I work in Pennsylvania. Well, I had a client at one point. He came in and he worked for a major network affiliate in Philadelphia. Well, that's in Philadelphia, right? Well, they hit him with a bank levy. They hit him with a wage execution, and you know how they got away with it? Because that network affiliate, that television station, had a facility in New Jersey, a physical presence. So the creditor's attorney, served a wage garnishment against the employer at that New Jersey facility. So even if payroll and HR and everything are not in New Jersey, and you report to work in Pennsylvania or in some other state, if there's some presence in New Jersey, they may well be able to come after you. So each situation is different. If you're facing that, talk to a lawyer. But the point is, I don't want you to rely on that myth, on that lie that you're somehow safe. All right, look into it further. Find out whether you truly are unreachable by that creditor. And even then, this is something that's going to be around for a long time. Oftentimes it really is best to try and deal with it. And if you really are indeed beyond practical reach of that creditor, that you may be able to use that as leverage to settle for less with that creditor, saying that they may not be able to collect it otherwise. Okay, so don't believe that myth. Talk to a collections attorney about that. The third myth is, I'm judgment proof. Well, that's a more extreme example of the I'm out of state, they can't touch me, but really it gives temporary comfort. Okay. The judgment proof basically means that you either have no assets or you have assets that can't be reached. So, for example, I'm unemployed. Okay, well, they can't garnish you while you're unemployed because you either have no stream of income at all or you're receiving New Jersey unemployment. And under New Jersey law, you can't garnish unemployment benefits and you can't levy on them in a bank account. So that may well be a defense. Say, okay, they can't garnish my wages because I'm on unemployment, but they can still levy on a bank account depending upon what money is in there. Now, if you have unemployment benefits, if you have that are sitting in there, or some other monies that aren't touchable under New Jersey law, or you keep less than $1,000 in there, then that may well help you. But remember, even though a creditor can't ultimately get the money out of a bank levy, they can still levy the account, which freezes your money, which causes problems with being able to write checks, pay bills, whatever it is you're doing with your unemployment money, while you're straightening things out with the court and getting the money released. Also, you say, well, I'm upside down on my house. I owe more than it's worth. They can't, or I don't own real estate, so they can't come after real estate, or I don't have any equity that they can come after. But really, this is a short-term solution. Do you really want to live like this your whole life? You may be judgment proof now, but eventually they're going to come after you and you're going to have assets. Hopefully life will get better. You'll get a job again, maybe a nice high paying job. And the more you make, the more they can take in a wage garnishment, the more they can take out of your bank once you deposit that paycheck. Okay? After a few years of making mortgage payments, maybe you now have equity in your home that they can reach. Okay? So really, it's a temporary situation, you're being judgment proof. And really, another point to be made is, it's really the best time to file bankruptcy. Think about it. You file bankruptcy to get rid of the debt, and you say, look, I have nothing. I'm judgment proof. I don't have a stream of income. Certainly not enough to pay more than my regular monthly living expenses, let alone pay any of my debt. I don't own anything of any significant value. There's no equity in my home, or I don't own a home, whatever. If you're in bad enough shape to be judgment proof, that's the perfect time to file bankruptcy with the lowest risk. And again, every case is different. Talk to a bankruptcy attorney. But that could be the best time to file bankruptcy while you're judgment proof. And then you're done. Then that debt's wiped out. If you wait until things get better and then you go to file bankruptcy, it might be more problematic. So don't tell that lie to yourself. Don't say, well, I'm judgment proof. They can't get me. I don't have to do anything. You really should still at least talk to a debt professional and get the right solution. Don't live in that false hope. Next lie that people tell themselves is, as long as I pay my creditors something, $5 a month, $25 a month, as long as I pay them something, they can't come after me. Oh, yes, they can. They can say, thank you very much for the money. Well, they have to credit it against the balance due. But they don't have to stop in their efforts to come after you. They can still garnish your wages. They can still levy on your bank account. They can still cause problems in your life even though you're making a payment of some sort. Unless they've entered into a deal with you for those payments and say, as long as you make these payments, we don't do anything, they're not bound. You're obligated to pay the debt anyway, and you've made a payment, okay, that you do something you're supposed to do anyway, they take the money, they credit it, but that doesn't mean they can't come after you, okay? So a service I render for a lot of clients is people come to me and they need a deal made, and they need to say, look, I don't want this creditor levying on my bank account or garnishing my wages. So I'm able, in most cases, to go in, talk to the creditor's attorney, work out a deal for payments, and then file paperwork with the court that says as long as they make these payments, we won't do anything. So there's an agreement. They've accepted your payment arrangements. It's in writing. It's official with the court, which protects your rights and prevents them from doing anything. So unless there's a deal in place for those payments, it doesn't help you, okay? The fifth lie that people tell themselves is they'll get something by certified and regular mail. In New Jersey, you can serve a lawsuit on somebody through the mail. And what will happen is you serve it by certified mail, return receipt required, and by regular mail. And the rule is, as long as the regular mail does not get returned by the post office, or the certified mail come back saying not at this address, I mean, both bounce back. If you don't sign that green receipt card, if you don't acknowledge receipt of the certified mail, but the regular mail went through, you were served. So don't round file the regular mail copy and ignore the certified mail copy. You're just going to complicate things. You know, they're suing you. You need to pay attention. You're only going to have 35 days to file an answer if that's what you want to do, or talk to an attorney about making a deal, or just contacting the creditor's attorney and making a deal. Don't think that you're Teflon, that it's bouncing off because you didn't accept the certified mail. Okay, doesn't work that way. Okay, as long as they get you with a regular mail, you've been served, and that's really something. Once they're suing you, you should be paying attention. So again, don't tell yourself that lie. Okay. So that's it for this episode of Lunch with a Lawyer. I hope you got some good information about that. If you see this video on Facebook and you like the content, be sure to give it a thumbs up. That helps the search algorithm for other people to see it and get this good information. If you can always share it, hit that share button and share it on your wall. Or if you know somebody that's in financial difficulty, but you don't exactly want to post this on their wall and you want to be a little bit more discreet about it, you can share it through Facebook Messenger. You can do that as well to get that good information out. This video will also be posted to my YouTube channel at richardsonlawoffices.tv. If you're watching it on YouTube, again, give me a like, give me a thumbs up. Helps the search algorithm, helps more people find this information. You can also share it with other folks. And also, if you like this video and have seen others of my videos, subscribe. Hit that blue R button and subscribe to the channel, and you'll get notifications when I post new videos. That happens every month. So that's it with Lunch with a Lawyer. Enjoy your summer, and I'll see you in August.